we can answer them as we go along. And then we also will be sending you an email to the email you used to sign up with this with a couple materials. So first and foremost, our feedback form, which both gives you a place to give us feedback, and it also allows us then to know whether or not you'd like us to reach out to you to set aside time to come in and meet with one of us. Our initial consultation process, we schedule them for about 2 hours. They are complimentary, so if anything we talk about today raises concerns for you and you want to come in and talk about this situation and see what might be done for you or your loved one, then please feel free to use that form, and that'll let us know that we can reach out to you to schedule something. And we are also going to be sending you out a chart of, sort of a chart of it anyway, of sort of a least restrictive to most restrictive option for when somebody might need a guardianship or is declining in capacity overall. So it kind of goes left to right if you're looking at it from least restrictive to most restrictive, just through the different types of things that somebody might use. To get started, maybe talking about what is guardianship might be helpful for people too if you haven't gone through this process yourself, or maybe you have kind of just a vague understanding of it. A lot of people are familiar with guardians in the sense of like when you have minor children and you want to name them in your will for those minor children so that you can have somebody take care of your kids, the people you would want to take care of your kids if you were to pass away while they were still minors. But guardianship as a process can happen for a variety of individuals, not just minor children after the death of a parent. One of the most common uses for guardianship, at least in our industry, we see is as somebody either gets older and maybe has cognitive decline due to Alzheimer's or dementia, some sort of cognitive impairment on that side, or maybe even adult children who have special needs that need a continuing parental relationship after they reach 18, right? So it's not just minor children who might need guardianship, it's also adults with certain special needs, or even older, elderly individuals who are cognitively declining due to Alzheimer's or dementia. Guardianship as a process, though, how it tends to work is oftentimes a family member or loved one petitions the court for guardianship over the individual, who is also known as the ward or the proposed ward in this case. How this generally works is the family is oftentimes hiring an attorney to help with this process, although it's not required, but they may likely be doing that. There's cost involved, there's a court process involved. What that family is doing when they're filling out the petition for guardianship is they're looking at what sorts of rights do we want this individual to still maintain themselves versus what do we want shifted over and taken from that individual over to the guardian. So what guardianship really can be is a shifting of rights from one person to another. So when we're talking about most to least restrictive, what we're really talking about in this case is how restrictive it is to the person's right to make certain decisions. Now, once that petition's filed, the court will always appoint what's called a guardian ad litem to determine whether or not this individual really needs a guardianship. And a guardian ad litem is an attorney. They're supposed to be independent and assess the individual's need for a guardianship just to make sure that nobody's taking advantage of the situation or anything like that. And also to determine whether or not the person, the proposed ward, actually maybe needs representation themselves if they contesting the guardianship or don't understand what's going on, right? If it represents their rights. So what can happen a lot of times with guardianship is not only are there 2 attorneys involved, but there might end up being 3 attorneys involved when the proposed ward either contests the guardianship, if a family member contests the guardianship, or if the guardian ad litem thinks it's in their best interest to be represented independently. Then there could be a 3rd attorney involved. And that attorney's job then is to represent their best interest, to potentially contest the guardianship, fight against the guardianship, right? So it can be not only a restrictive process for the rights of the individual, it can also be a drawn-out process and potentially a lengthy and expensive one when it comes to just trying to get decision-making authority for somebody and help them out and manage their finances, manage their healthcare decisions. So when we're talking about what could be the least restrictive option, and getting things in place to help this individual out, The first thing that we generally look at, and if you are able eventually to look at that chart that I was talking about earlier, you'll see that the least restrictive thing is to get kind of release forms in place. And those are things like HIPAA authorizations, release of information forms, just things that allow you as a family member to at least receive information related to that person's care or financial situation so that you can help them make the best decision. Maybe they don't really need you to make decisions for them, but it allows you to help. So HIPAA authorizations are probably one of the most common release forms that people are familiar with because we've all signed a lot of those, and that is what allows healthcare organizations to release information to a third party about that person's health. The kind of next step up, and these are always a great idea even if you have those HIPAA authorizations in place or the release information in place, is to look at getting powers of attorney in place for your loved one. So a power of attorney is a document that says that I, as the individual, grant these authorities, enumerated in the document, to this person to make decisions for me. Or not for me, but they can also make these decisions as well as myself. So a power of attorney is a very one of the least restrictive options you can have, but also actually one of the most flexible options you can have for somebody in order to step in and make decisions for them. So powers of attorney vary in what they allow the agent to do. The agent is the person that's granted that authority. It depends a lot on what is actually in the document itself. Not all powers of attorney are the same or grant the same authorities. So especially when it comes to a financial power of attorney, it's really important for you to understand, or for your family to understand, what's actually in the document. And I don't expect you to read through that document and understand every subsection, but at least talk with the attorney who drafted it, talk with an estate planning attorney to get it reviewed, to see what it is that it actually allows. So if that is a pretty expansive financial power of attorney, that individual who granted that agent that authority may never need a guardianship for financial decisions because they've granted pretty much everything that that person would ever need to make decisions on. They've granted them that ability. Now, powers of attorney, contrasting that with guardianship, is not actually shifting rights over from one person to another. A power of attorney is essentially like if I appointed somebody as my power of attorney agent, I'm not saying I'm giving them my right to make that decision. They can't override me if I have capacity. But I am duplicating my authority. And especially if that financial power of attorney is what we would refer to as immediately effective, meaning the moment it was signed, that person, the agent, can start making decisions. It's really a helpful tool in a lot of situations where maybe it's not even a capacity concern, but mom and dad just want assistance from one of the kids to help make decisions or manage finances. So it is very, it's the least restrictive option, but also in one of the ways the most flexible options, because you can grant a lot of authorities in a power of attorney, especially when it comes to long-term care, like cost planning, that guardianship courts just won't grant. And just to give you some examples on what authorities you might have granted in a financial power of attorney that a guardianship is unlikely to grant for that guardian, that would be things like making gifts of a certain amount, creating certain types of legal arrangements or documents on that person's behalf, maybe doing certain types of updates to ownership of accounts or beneficiary designation changes. You can really be very flexible with a financial power of attorney, and when it comes to a loved one going into a long-term care facility, grant the most authority to have flexible planning options for them. Guardianship courts tend to be pretty hesitant to grant certain authorities over gifting to the family members because they don't want anybody to be taken advantage of, right? And they also tend to not allow the creation of certain types of trusts, for example, on that person's behalf. So our options as estate planning and elder law attorneys actually become pretty limited a lot of times if guardianship is the only option versus if that person has had financial powers of attorney that grant all of those authorities. So powers of attorney are great tools, and they're, in my opinion, and pretty much everybody in our office's opinion, absolutely essential to have in order for flexible planning to be available to that person. There are times, however, where powers of attorney are not an option for somebody, or at least updating their current powers of attorney are not an option. And this is where it's really important to try to do these documents or update these documents relatively frequently. Every 3 to 5 years is a good benchmark, or get them in place as soon as you can. Because if somebody has declined in capacity and is unable to sign these documents from not a physical standpoint, I get people who ask that question a lot or say, well, mom and dad can still sign their name, I just don't know if they'd understand the document. And that's the latter part of that is what I'm really referring to, is can the individual signing the document understand enough what they're signing that it wouldn't be overruled if it was challenged in court, for example. So you want to try to do this while the person who would be signing it still understands generally the authority that it grants. They don't have to understand necessarily what an irrevocable trust is, or what a special needs trust is, or how Medicaid works. People with perfect capacity don't always understand those things, and that's fine. What they need to understand is generally who are they granting this authority to, what types of authorities are they granting, like bill paying, maybe being able to change account ownership or file taxes, general things like that. And can they understand the potential impact of that? If this person can move finances, that means they can maybe do X, Y, and Z. It's not necessarily an overly in-depth understanding that they have to have, but they have to understand the general effect of it. It's kind of like if you were to sign a contract for something. Most people don't understand every subsection of that contract, but they generally understand what it is. Oh, this is what this contract is doing for me. I'm buying this house. I'm purchasing this vehicle, right? And this is what this does. So we love powers of attorney. They're the best tools you can have if you can get them in place, but that isn't always an option for people. So if powers of attorney are not an option, or if you're trying to get an authority in those powers of attorney that are added to those powers of attorney, and that person can't sign a new document, sometimes you do have to go through guardianship in order to try to get more authority. And there are certainly times when family members come in and talk to us where their loved one's about to go into care and they want to get these documents in place. And one of our attorneys sits down with the individual and talks with them, tries to assess their capacity, and sometimes we just can't have them sign it. And so that is oftentimes where we're looking at then guardianship as the next step, just to get some authorities in place at the very least, so that that person can still have somebody step in and make decisions. One thing with healthcare powers of attorney that a lot of people don't know about is that even if you have one of these in place, there are situations in which you may still need to go through at least a temporary guardianship in order to get somebody transitioned into a care facility. So when you fill out a healthcare power of attorney or sign your healthcare power of attorney, you can elect to either allow the agent under that document to admit you to a long-term care, assisted living, or skilled nursing facility, or you can say that they don't have that authority. If somebody needs that level of care, but the document doesn't grant that authority, you may, as a family member, still need to go at least petition the court for guardianship over that decision, so that you can get your loved one the care they may actually need if care at home isn't covering that anymore. There are also situations where we've had clients who have that granted authority in there, but in the moment don't understand why that decision is being made and contest it or are pushing back on it. And even with that authority granted, that agent can't override that individual's wishes. So if that's the case, sometimes guardianship for that decision is still necessary. But you're still better off having these documents and having the expansive authorities they have than, just saying, well, if I might need guardianship anyway, I might as well do nothing. Because at the very least, if that's the only reason we're going through guardianship, we know we have other planning options available once that part is finished. Moving on from powers of attorney, there are certain documents here in Wisconsin that are actually relatively new in terms of existence. These are not like they've been around forever. And this is what's called a supportive decision-making appointment. And essentially what that is an individual signs a document. They actually don't have to have even the same level of capacity to sign this document that you would have under a power of attorney or a will. and they can appoint certain individuals who are their supporters. They're people who are allowed to help them make decisions. Now, this document doesn't carry the same weight or authority that a power of attorney does. So it's sometimes used in conjunction with a power of attorney, or if the person can't sign a power of attorney, but it's not a replacement for a power of attorney. So the supportive decision makers can, potentially be in the room with the individual, hear the same information that they are receiving, but they can't speak on their behalf. They can't override the person's wishes. They are really there to say, hey, this is what that means, or this is what this person is explaining to you. What would you want, right? So it's not restrictive at all, but it's also limited in its utility in terms of, making certain decisions for that person. So they're great tools to use, and they can be a very unrestrictive thing to use, but you would always prefer to use these supportive decision-making documents in conjunction with a power of attorney if you can, and not treat them as a replacement. And again, there are certainly times where that is the only option for somebody, at least for the time being. Where these really come into play a lot, that I've seen anyway, is when it's a parent trying to help out their child with special needs who is becoming an adult and moving past that point where they have parental rights. So the most restrictive option, though, that we tend to run into with guardianship type decisions is, of course, guardianship itself. And I touched on that a little bit of why this is the most restrictive. It is truly a selection of rights that you're taking from one person and shifting over to another. Just like when you were a child, your parents had the rights to make certain decisions for you. It's almost a continuation of that relationship, or a similar relationship to that. And so this is not saying that guardianship is a bad process, or like you should always avoid it no matter what, or anybody who tries to petition for guardianship is somehow taking advantage of people, because that's just not the case. It is a tool like any other, and sometimes that tool is necessary. But because it is truly a shifting of rights from one person to another, it should always be the last resort if possible, because you want to do the least restrictive thing. You don't want these things put in place and taken from people if it's something that they don't need. And courts are sometimes reluctant to remove that guardianship once it's in place. So sometimes if capacity changes, maybe somebody was incapacitated in the moment and they needed that guardianship at that time, but it's no longer necessary, courts are much more reluctant to recertify that person's capacity and give them their rights back and terminate the guardianship than they are to grant it in the first place. And so you want to be careful about whether this is actually necessary, if there are other options available. But if there are not, if that's the only option available to you, if that's what's being recommended to you by an estate planning attorney or a guardianship attorney, it very well could be the best thing for that individual. But we always prefer to do the least restrictive thing, because then that can be revoked, that can be changed. Powers of attorney can be changed as long as that person has capacity. So those are not set in stone unless the person wants it to be. And really it's up to that person whether they stay in place. Whereas guardianship, you now have a court involved, and it's up to the court whether those stay in place. And so if you want the least amount of people involved as possible, and you want the most flexibility, powers of attorney, supportive decision-making documents, those are going to be the best route to take if you're trying to avoid having to go through that guardianship process. So guardianship, like I said, can be necessary, but you just need to be cautious about when you're using it. It shouldn't be the first line of defense for anything. I've had clients come and talk to me in the past and say that's a different approach than I've heard people take, where some people say you should never use guardianship, it's too restrictive. And I think what gets lost in translation a lot of times there is that it's a tool to use, the same way a power of attorney is a tool to use, or a trust or a will is a tool to use, and it depends on your circumstances. So I'm not one to ever say that something should never be used. It just needs to be used in the right circumstances, in the right way. So I'm not seeing any questions right now, but as always, keep an eye out for that email with that feedback form that I mentioned for the complimentary initial consultation if you'd like us to reach out to you. And then that kind of least restrictive to most restrictive chart I was talking about will be sent out to you as well. And then our topic next week is actually wills versus trust. So it is our public seminar in Oshkosh. So that is actually going to be in person. We have a 2 p.m. and a 6 p.m. session. And if you'd like to sign up for that, please feel free to reach out to us or sign up on estateplanninglive.com and register for it. It helps us keep a head count and make sure that we're not over capacity. So that is where we'll talk more in depth about wills, trusts, powers of attorney, and long-term care, and the types of things that you might need to be aware of if you're doing your own planning or working with an attorney to do your planning, rather. Keep an eye out for those feedback forms and that handout, and then we hope to see you guys in person next week at our